and be good to go. Now, some additional steps that need to be taken within your municipality. You should have read and understood what your particular municipality's sexual harassment and discrimination policy says and means, and know who to go to at your municipality if in fact you have a complaint to register. So your compliance officers should be well versed in what the policy says. They should know how to field a complaint and then commence an investigation. So you should know how to file a sexual harassment or discrimination complaint. If you do not know where the complaint forms are located, speak with your compliance officer or your supervisor, and they should be able to direct you. If you don't understand your policy after this training or at any time, you can go to your compliance officer at the municipality and follow up with them to get a clear understanding. Answers should be provided to any of those questions you have within 24 to 48 hours. Now, there's been some confusion that's come our way. Some municipalities have misinterpreted the law as being rather a NYMER requirement, that this training is NYMER driven, NYMER required. It's not. We're making it easier for you to be in compliance with a New York State training requirement. So the training we're about to engage in here is compliant with New York State's requirements, and it's your responsibility to implement the policy, to keep track of your employees' training compliance, and to monitor appropriate behaviors in the workplace, especially if a complaint arises with respect to some aspect of harassment or discrimination. So with that, we're going to move right on to Steve Curlin. Steve, take it away.
All right, thanks a lot, Dave, and thanks for that very detailed description that really brings it home. Again, as Dave mentioned, my name's Steve Curlin. I'm a senior risk control specialist with NYMER. And we already mentioned that this training is compliant with the requirements specified for the New York State sexual harassment legislation. You probably heard about this, you heard a lot about this. So you're in compliance if you're sitting and listening to this course. By the end of this session, you should be able to, first of all, discuss what prohibited contact and conduct is, including sexual harassment. You should also be able to discuss the internal complaint procedure, reporting options, external reporting options as well. It doesn't have to be an employee, it can be a third party that files this complaint, or you have a complaint against an individual. You should also, at the end of this session, be able to discuss the internal investigations and what those possible outcomes will be. Sometimes a complaint does not rise to the level of sexual harassment. And, we'll talk a lot about that going forward. You should be able to review and understand what the employee's responsibilities are, what the supervisory responsibilities are. And you should be able to answer general questions and questions regarding policy, your policy actually, that you have in your individual municipalities against discrimination and harassment. So in general, everybody has the right to come to work and be treated with dignity and respect. Now that always happens, doesn't it? Well, I don't think so. That's your first question. That's your first quiz question here. And the state of New York feels so strongly of the fact that everyone has the right to come to work and be treated with dignity and respect, that they do require this annual training of all of us. Let's talk a little bit about and bring it home to the current situation with COVID-19 and the increased unemployment which occurred because of this. Now, we also know over time, being an insurance company of specializing in municipalities, that discrimination claims tend to increase as employment increases. We all know that. We should be very mindful of the Americans with Disability Act, the ADA. You've probably heard that terminology. We have to make reasonable accommodations for disabled people that can do the job and to allow them to do the job. We have to be careful of discrimination based on age, pregnancy, other bases. Now, the U.S. Equal Employment Opportunity Commission, which enforces federal civil rights laws, has made it clear in its position that employers, including municipalities, may not prevent older workers, pregnant workers from returning to work, even if that employer feels that because they're vulnerable, they're doing the right thing. No, we have to allow them to come back to work. And we also should be very mindful and keep in mind harassment based on origin of descent and race. Effective February, the New York State Human Rights Law will apply to all New York employers, no matter of the workplace size, will protect non-employee service providers. These would be independent contractors, consultants, vendors, from all forms of unlawful discrimination and harassment based on a protected class. Now, we're going to talk a lot about what those protected classifications are that we cannot discriminate. And we're talking about work-related decisions based on those protected classes, such as hiring, firing, promotions, work assignments, overtime, work conditions, raises. That's what we're talking about here, and non-discrimination based on those things. Well, let's talk about some of the significant laws that have come down over the past, well, long period of time. We start out with the Civil Rights Act of 1964, which was really put things in motion, which was the original act. It was federal in nature, prohibits discrimination based on race, color, religion, sex, or national origin. And you'll notice that it prohibits retaliation. So if somebody files a claim, if somebody has a complaint, other individuals cannot retaliate against that person. And you'll notice that all of these acts also prohibit retaliation. Then we went into the Pregnancy Act, Pregnancy Discrimination Act, which prohibits discrimination based on pregnancy, childbirth, medical conditions relating to pregnancy or childbirth. Then we went into the Age Discrimination and Employment Act, which prohibits discrimination based on age. And that cutoff's 40. 40 years old is what they talk about and older. And I'm hoping the new 60 is 40. And also prohibits retaliation in all of these acts, as I mentioned. And we're talking about the ADA, the Americans with Disability Act, okay, which prohibits discrimination based on disability. We have the Equal Pay Act, meaning that if a man and a woman do the same job in the same workplace, equal pay should apply. Then here's one we kind of had to look up a little bit, the Genetic Information Non-Discrimination Act. Now, medical science has come a long way in genome testing, where they can reasonably predict if an individual is going to come down in later life with a serious illness. So this act prohibits discrimination based on genetic information, including the genetic tests, family members' genetic tests, and family medical history. Of course, there's other laws of privacy regarding medical history, but this act kind of solidified that an employment, a work-related decision, you cannot be discriminated against based on that genetic testing. I hope that makes sense. We had to study that one for a little bit. And then, of course, we had the New York expanded this a little bit, quite a bit. The New York State Human Rights Law. And you can read through this a little bit. And basically, it creates what New York State and some other states followed suit, what those protected classes are. And we're going to get into that in detail. So if an individual, overall, the act says that an individual in work-related decisions in the workplace or outside of the workplace cannot be discriminated against based on, and we know the first follows the federal act: race, color, gender, religion, creed, sex, pregnancy, or sexual orientation. But it takes it a little bit farther. We add to those protected classes with self-identified or perceived sex, gender identity, gender expression, transgender status, national origin or ancestry, citizenship, age, disability, military or veteran status, marital status, familial status, criminal or arrest history. We should put a little asterisk by this one. There's certain jobs within certain corporations, say dealing with children, where if you have an arrest of say, a certain type, you can be excluded. But for the most part, criminal and arrest history cannot be used to discriminate against an individual in the workplace or being hired. Genetic predisposition or carrier status, domestic violence victim status. It's quite a list. So take a look at that. So what is harassment? Let's break it down a little bit. Let's talk about what sexual harassment is and what it is not, okay? In general, and the cases that I've read and been fairly close to, they always talk about this created a hostile work environment. And typically it's multiple acts over a period of time, which definitely created a hostile work environment. Unless it was a single act that was so pervasive in manner that it created that hostile work environment. The example of that might be the individual at the holiday party that corners somebody, and we're all adults here, we can understand. That would be a single act that might be sexual harassment and create that hostile work environment. But typically it's pervasive over a long period of time. So hostile actions taken against an individual because of the individual's protected class. If you can, get your mind around that. We talked about what all those protected classes are. So discriminating against that individual in the workplace and work-related actions based on those protected classes create a hostile work environment and are illegal under the act. So in general, this would be things such as the old water cooler jokes, the gestures, the nicknames, somebody says, "Steve, you really rock those jeans." Well, I wouldn't mind it once, but if it occurs over the next 6 months, somebody's going to, not appreciate that, and it could lead to a sexual harassment claim. Comments on personal appearance, touching. Now, obviously, touching and physical acts, easy for me to say, can also be a crime, and we'll talk about when that rises to the level of crime and not just a claim or complaint regarding sexual harassment. Interfering with somebody's workstation, sabotaging. There's an unlimited number of ways that a hostile work environment can be created. But basically, when there is no room in the workplace for these type of actions, and and I know this group will have no issue with this, but I want you to understand what is and is not sexual harassment or discrimination. It can happen between supervisor and subordinate. It can happen between an employee to a peer employee, a third-party provider, a consultant, for example, a third-party contractor, and an employee. Quid pro quo. Now, I didn't take any Latin, but I'm told it means this for that or something for something. Just even a suggestion to say, well, you know what, if we were dating, I could get you the best work assignments, a lot of overtime, and even that suggestion is quid pro quo, and per se, it can be a form of sexual harassment. A lot of times that occurs between a supervisor and subordinate. And obviously, these days, it doesn't matter what the gender of the parties is, it's just totally irrelevant. A little bit more about sexual harassment. Harassment on the basis of sex, sexual orientation, self-identified or perceived sex, gender expression, gender identity, and the status of being transgender, all of those things are part of that protected class under the law in the state of New York. And for example, if the harassing person just doesn't understand and doesn't, he thinks that somebody doesn't conform to his idea of what gender is. That's sort of what we're talking about now. So some other examples are unwanted sexual advances, propositions, sexual comments, noises, gestures, jokes. Okay, be very careful about pictures in the workplace. Now, you know, I remember many years ago in this business, we used to see a lot of the pictures and things, not so much anymore, but it still does occur. And keep in mind that it can be on your computer, on your cell phone, and that is the same as hard copy. It doesn't make any difference. And any you know, act of a sexual nature can be sexual harassment and create the hostile work environment. So where can it occur? It can occur inside the office, obviously. It can occur at employer-sponsored events, the old softball team or the bowling league or the carpool, any of these things. Conferences, okay? Office parties, that's a big one. Off-site or non-working hours. And I always have an individual back when we taught all these in person, it was usually a gentleman would come up to me and say, listen, I can't say anything to a woman these days, can I? And I said, well, what do you want to say to them? And, oh, I want to ask her out. I said, well, that's not sexual harassment. But then again, if you text her 25 times, she says no, and you text her 25 times, possibly with off-color photographs, that would be sexual harassment. And so, you know, we have to be very careful. What is not sexual harassment is asking a coworker for a cup of coffee or to have a drink after work. That is certainly not sexual harassment. But you get the idea where that line is. And we'll talk some more about that. Retaliation. Because if you noticed in the statutes, retaliation was prohibited and specifically described in each of the legislation. So the anti-discrimination statutes prohibit discrimination against an employee or job applicant or against a closely associated third party because he opposed a practice that is prohibited by the statute. Okay, he spoke out about a practice and now he's being punished as a result of speaking out about the anti-discrimination statute. Or he has made a charge, testified, assisted, or participated in a discrimination investigation, proceeding, or hearing. Now, you'll notice when you, and hopefully all of you have read your individual policy in your municipalities regarding anti-sexual harassment and discrimination. And you've seen that it's a requirement that, if asked, to assist in investigating a complaint. And so somebody that has assisted in a complaint and then is punished by other individuals. Now I use the word punished, but it can be in many, many different forms. That is retaliation. Okay, so the standard is the adverse action that well might have dissuaded. It's any adverse action. It can be kicking them off the softball team, throwing them out of the carpool. It can be changing their work assignments to something else. It can be, there's many, many ways that retaliation can take its form. And so we have to understand overall what that is. It dissuades a reasonable worker from making it or supporting a charge of discrimination. I hope that makes sense. Okay, a little bit more about retaliation. It's breaking it down a little more. It's any action taken to alter an employee's terms and conditions of employment. For example, a demotion, that's pretty clear cut, but it can also be insidious, as we mentioned before. Harmful work schedules, change in locations. Retaliation can be an adverse action taken by the employer. When I say employer, it could be only the supervisor of that individual. That could have the effect of discouraging an employee from making a complaint. The negative action need not be job related, as I mentioned just a second ago. And it can also occur at the end of employment, such as not giving a reference or giving a very negative reference. All of these are examples of retaliation. Well, there's some landmines waiting to explode. Let's talk about a couple of these. Well, touching, we know, can be a serious and pervasive thing that, if allowed to continue, a lot of times does result in a complaint regarding sexual harassment. Social media. Be very, very careful about what goes onto your social media. There was a claim that I read about some time ago where the individual, after she left employment, filed a sexual harassment claim. But then on her Facebook page, there she was, hugging and kissing and really enjoying the company of the exact people she was filing a sexual harassment claim about. So social media can be, something to really watch and be mindful of about because once it's out there forever. Dating in the workplace. Well, that's certainly a landmine waiting to explode. We all know that every relationship ends happily ever after, right? Well, wrong. And there can be a lot of animosity in the workplace, and it can create a hostile work environment. If these individuals break up and there's snide remarks and a lot going on between them, some unfinished business, we're all adults. We understand how this happens. So I would be very careful about dating in the workplace. Nicknames. When you have a nickname for somebody, they may not like it. And, be careful about that. And the water cooler jokes, the dirty jokes, all of these things. And also work-related off-premises conduct. If, that's something. Now, people always ask me, they say, well, I can do anything off duty, right? Well, not really. You also have to be careful of conduct that occurs outside of the workplace and off duty. Comments on personal appearance is something to, all of these things, really, there is no place in a workplace for this. And again, if you act professionally and treat everybody with dignity and respect, then that's sort of what we're looking for here. you don't want to be involved in any conduct or be involved in any discussions, either written or verbal, or that you wouldn't want to have to sit and tell your family or see it in the newspaper or have it read, have your conduct or what you said read in open court. That's kind of the litmus test that we should be thinking about in our personal actions. So here's a couple of questions for you. True or false? What I do off duty can't be considered harassment. True or false? Well, we know that's false. Off duty, on duty, doesn't make any difference. Another one is sexual harassment is only between the boss and subordinates. Well, we know that's false. We talked about the fact that it can be between peer subordinates. It can be between a third-party contractor, a consultant, and a supervisor, an employee, or anybody in between. Here's another one. True or false? Sexual harassment has to be between the opposite sexes. Does anybody think that's true? No, come on, it's 2020. It's been a long year, but I think that nobody believes that's true anymore. It can be same sex, opposite sex, doesn't matter. And another one, men can't be victims, right? Well, it is true that in the area of sexual harassment, there's fewer claims against men. However, it certainly doesn't exclude the fact that a man can be a victim of sexual harassment. Let's look at another one. Unless the person tells me it's offensive, I don't have to stop. It's not sexual harassment. Well, it's the action of the complaint of the accused individual that is going to be evaluated. It's not the reaction of the individual filing a complaint. Does that make sense? It's the action that's evaluated, the words that are evaluated, not the response. Okay. And Bill's done that for years. Everyone knows it's a joke. He doesn't mean anything by it. Well, we've heard that one for years. And believe me, that doesn't hold water anymore. And so the example that I've heard about and sold a claim and actually, got this taken care of pretty quickly is that, every day the supervisor would come in and give a neck massage to actually his secretary. And this went on and she complained a couple of times, told him she didn't really need that massage. Please don't do that. And eventually she went and, did file a complaint. And that action did in fact stop pretty quickly. So how do we file a complaint? You have your individual policy within your individual municipalities, and you should read that carefully, I think as Dave and also Karen had mentioned, but we have to promptly report conduct. And so that gives the employer the opportunity to intervene quickly before anything gets out of hand. And actually, this is a loss prevention technique. Promptly reporting conduct can allow the supervisor who may not know of this conduct to promptly intervene and prevent a claim, prevent more trouble. You have to complete a reporting form. It can also be in writing, also verbal or in writing, it doesn't matter, and also cooperate in the investigation. What is the investigative process? The employer will investigate all claims of discrimination promptly, whether it be in writing or verbally. The investigation will commence and be completed promptly. Interim measures may be taken as necessary. And I've seen this before. Individuals, go work in a different cubicle. We're going to get to the bottom of what happened. This is an interim measure. The investigation will be kept confidential as much as possible under the circumstances. Now, We also know that all employees are required under the policy to assist in the investigation, but also know that it's going to be, you shouldn't be talking about it openly within the workplace. It should be kept as confidential as possible. And all employees are required to cooperate as needed in that investigation, as I mentioned. Okay, the complainant and the accused individual is then notified of the final determination, and as applicable, that appropriate corrective action has been taken. What are the outcomes? Well, the first outcome is that did not rise to the level of a complaint which has merit. There can be, the first outcome is that no prohibited conduct was found. And then if prohibited conduct was found, there can be outcomes there. There can be reassignment, counseling, discipline, up to and including termination, if it's severe enough, training, or the employee assistance program. So we want to treat, and this goes back to one of the polling questions, the employee responsibility is to treat all coworkers and third parties professionally and with dignity and respect. You're there to work, and everybody has the right to come to work and be treated with dignity and respect. And there's no place in the workplace for some of those things which we just talked at length about, okay? And the employee has a responsibility to read and ask questions and understand the employer's policy against discrimination and harassment. You should commit to the policies by word and example. You should stop and/or report potentially offensive behavior, cooperate in investigations, and prevention initiatives. Let's look at the supervisor's responsibilities. Again, treat all employees with dignity and respect and provide a good example by their own conduct. The supervisor should intercede and stop potentially offensive behavior. The supervisors should take necessary immediate corrective action in response to an inappropriate behavior. So if you're a supervisor, understand this course, understand the actions that might be inappropriate, and take that immediate action. So again, also assist employees in regards to anti-discrimination and harassment policies, understand the wording so you can explain it as a supervisor, and including that complaint procedure, and a few more things. A supervisor should report to the compliance officer any discriminatory or harassing retaliation reported or observed. Encourage employee cooperation in discrimination, harassment investigations, and preventive initiatives, and also ensure against retaliation. So if the supervisor knows that two individuals there's a complainant and an accused individual, it might be pretty important to have a discussion with either of those individuals regarding retaliation and the fact that retaliation is part of the legislation and prohibited. Supervisors are evaluated and disciplined for discriminatory, harassing, retaliatory conduct and or on the basis of their action or failure to act with response to these investigations and complaints. So in general, if you apply the litmus test to actions, to conduct, and if there's any doubt, don't do it, don't say it, don't tolerate it, then I'm sure in this group we'll be fine. There are some additional protections and remedies that I want you to know about. The New York State Division of Human Rights exists, and a complaint alleging violation of the human rights law may be filed either with the Division of Human Rights or in New York State Supreme Court. Keep in mind now that effective last month, sexual harassment claims and complaints may be filed within 3 years. Before it was 1 year. You don't have to have an attorney to file. And for more information, go to www.dhr.ny.gov. The United States Equal Employment Opportunity Commission, the EEOC. Under the EEOC, an individual can file a complaint with the EEOC anytime within 300 days from the alleged sexual harassment. You don't need an attorney to file, but under the EEOC, and we're talking mostly discrimination here, a complaint must be filed with the EEOC before you can file in federal court. And for more information, go to the eeoc.gov website. Keep in mind, and we talked about illegal touching and things like this. A lot of these things do also constitute a crime. So many localities enforce laws protecting individuals from sexual harassment and discrimination. Contact your city, town, or county to find out if those laws exist. And harassment may constitute a crime at some point, like physical touching or coerced physical confinement or sex acts. Contact your local police department in that case.